Hello, hello, Spencer Sen here with Estate Plans Wisconsin. Hey, so I wanted to jump on and create a real quick video. Again, my specialty is helping people learn estate planning, proper estate planning, all of the ins and outs, everything, and easily. Okay, so I just had a client of mine or potential client of mine, and this happens fairly often because the information is so hard to find. They meet with me. I give them all of this very factual information, help them understand it easily, and they take it to their family and they discuss it. Well, here's the deal. 80% of this country has no clue about this information. Attorneys don't teach it, and it's hard to find. And even if you do, it's hard to understand and put it all together where it makes clear sense for people as to whether a will is enough for them or more, like a trust with a comprehensive estate plan and other documents. Okay, so bottom line, regardless, if people do not put a plan together, I want to be very clear in sharing with you that everyone needs at least a will and healthcare power of attorney and a healthcare directive. Period. Okay? At minimum, we all need that. Okay? But if you have assets on top of that, you're going to want to learn more. Okay? And then that way you have the ability to make an educated decision what's best for you and your family and all the people that are looking at things like this, that we all have to at some point. Having a plan, having a will is all about us, not what our kids want, not what our relatives want, not any of that. Think of it in the terms of I've worked my ass off my entire life, excuse my language, but we all work our butt off, most of us anyhow, our whole life to accumulate our assets and take care of and build our families and all this stuff. Most people want to, have their wishes carried out efficiently and immediately, but there's other things that people don't think about, like if they become incapacitated, what do they do? How do they prevent, Medicaid, other organizations, nursing homes from taking their assets when they need other care? Okay, so understanding comprehensive estate planning is understanding all the different aspects and variables involved in life and as it changes. Okay, so using TODs and PODs, transfer on death, and pay on death, is a very, very common thing that people know about or have heard about, but they only know part of it. You go to a financial advisor, some are good, some are bad, just like anything. And most of them, though, tell you the half truth because that's what they know. Okay. And what is a half truth? Well, if you have a beneficiary or if you have a TOD or a POD, that's all you need. Okay, but that's just simply not the case. That's half of the truth if life goes perfectly, which is one of the reasons I make these videos and also why I do what I do, helping people learn this stuff so they can make an educated decision what's best for them once they have the information. Okay, so let's talk about using payable on death and transfer on death designations. When people learn from me, just so you know, I'm an independent consultant, and when people learn this from me and feel that I'm a good fit for them, I help them get their plan done through Legacy Assurance Plan. Sorry for my birds. They obviously like this conversation. Anyhow, Legacy Assurance Plan has been around for almost 40 years now in finance, insurance, and estate planning, and it's a family-owned company. And they actually got burned doing a plan that wasn't done properly by an attorney. American Bar Association says the majority of attorneys out there are not qualified to do comprehensive estate planning. They just simply don't teach it, and they don't even know all the deeper ins and outs. They're creating documents, most of them. So be careful. Learn this stuff before. If you have questions, contact me. I'm happy to take you through it without selling you on anything. Okay, so one of the goals that people have with their estate, meaning their belongings, their affairs, anything like that, is to avoid probate. Okay? In addition to other things, all right? They want to have their wishes carried out immediately, efficiently. They want their assets, whether it's bank accounts, checking, savings, money market, investments, property, belongings, anything like that. They want it to be distributed efficiently and immediately. Um, well, so let's get into payable on death, PODs. All right, those do avoid probate. Okay, they do avoid probate without having a plan. Okay, but it's really more of a band aid. Okay, if everything in life goes perfectly, yes, it will work and avoid probate. But you know, basically, as you read this document, payable on death and transfer on death designations allow you to add a beneficiary to certain types of accounts and assets. Okay, the designated beneficiary receives the funds or other property at your passing without need for the probate process. Sounds great, right? These planning tools have a number of advantages and disadvantages. Okay, so let's highlight this area right here. Okay, payable on death designations. A payable on death POD designation can be used to transfer a balance of a bank or credit union account or CDs or to a beneficiary at the account holder's death. Okay, so we already understand that. The primary advantage of PODs is what they're is that they are very simple to establish and use. Okay, and they don't cost anything really. A POD can be added to any bank account free of charge. Okay, PODs have a number of disadvantages. A POD designation will override a contrary instruction in your will or trust. Okay? Some financial institutions allow just one POD beneficiary to be named. If multiple beneficiaries are allowed and named, account will be paid to survivors of those listed only, which may unintentionally disinherit grandchildren. Okay? So you have to think about what's important to you. What do you want? Again, you worked hard for your assets. You've got to this point. What do you want to happen when you become incapacitated or die? Okay? And who do you want to handle those decisions if you're incapacitated? You're typically smart. If you have a plan, you're going to want more than one. Okay? A POD cannot be used if the intended beneficiary is a minor. As noted above, PODs are limited to bank accounts and CDs, so they cannot be used to distribute all of your property outside of the estate. They cannot be used for that. Okay, so in comprehensive estate planning, a POD, a TOD, we call a band-aid. Okay, it will work if everything in life goes perfectly, which we all know never happens. Okay, so it's important to understand this stuff. PODs can complicate the administration of your estate. If your personal representative or successor trustee is not the beneficiary and does not have sufficient funds available from other sources. Finally, the designated beneficiary cannot access the account for your benefits if you become incapacitated. Okay, this is huge, guys. So if you have a TOD or a POD, and you have a plan, you have a will, you have an executor. A will has an executor, a trust has a trustee. Okay. If you have, just because you have the TOD and POD, the designated beneficiary cannot access the account for your benefit if you become incapacitated. So, having a plan, choosing that plan, understanding how to put that plan together is what we do. We help educate you, okay? Because of all of these side things, we call them unintended consequences that people don't know about. And this is specifically getting into the things and the detail that attorneys just simply don't get into with you. Okay, they're going to recommend one thing or another based off of what they know or what you say you want. So, for example, when people walk into an attorney and say, yeah, we've been thinking about getting our affairs in order, we need to get a will together. They're going to say, okay, great, I can help you with that. What would you like in the will? I'll write that up. Here's the cost they charge you. But what they don't do is say, by the way, do you realize that what you want will not be accomplished by a will? So what does that mean? Let's say you want to make it as easy as possible on your surviving family. Okay, well, a will is going to do the opposite. State law, every state has probate. Probate was created to prove a will, and that person died. And then notify all the creditors, the world, the public, anyone can dispute anything in your estate. When everything is all done, whatever is left, then we'll go to your surviving family. The executor you appoint in the will has to go through all of that stuff. The average of probate with an estate $250,000 or more is between 12 and 15 months. Okay, so a lot of people are like, holy crap, I thought a will protected me. No, most people still believe that. It does the opposite of what most people want. Anyhow, let's get back to PODs. PODs are also a result in the beneficiary receiving the fund all at once, shortly after your death. Okay? Again, it doesn't do anything for you if you become incapacitated. It will complicate things. Okay? So do not allow you to place any restrictions they do not allow you to place any restrictions on the inheritance of the account and should only be used when your asset distribution plan is very simple and direct and the beneficiary never becomes incapacitated or dies before you. If it does and then you die, it goes to probate. Okay, so again, Band-Aid approach. So as you go through your journey in learning this stuff, I know it's frustrating. You have to find somebody, A, that knows the information, and B, cares and is willing to share the information complete with you without selling you on something. Okay? I got into this because I'm passionate about as many families as I can teach in a day receiving this information so they can decide. Okay? If you need my help further, I'm here. Transfer on death designation. So now we went from PODs to TODs. Okay? If a TOD designation is used, the ownership of the account or asset is transferred at death of owner to the beneficiary. Sounds simple. TODs are widely available only for securities and brokerage accounts. Okay? In some states, TOD designations can also be used to transfer automobiles and real estate. Okay? It's state by state, guys. But again, this is going to create a Band-Aid effect as opposed to a solution to prevent unintended consequences that people have no idea that come up. Okay? A TOD is added to a brokerage account using a form provided by a broker, to real estate by recording a deed, and to a vehicle by adding a beneficiary to the title. All easy stuff. Okay? An attorney is not needed except for preparing a TOD. Okay, so you're still going to need to pay somebody on a TOD. All right? Why not have somebody that can help you understand a complete plan and get everything in place? Okay? Make it super easy, avoid probate, privatize everything, and have exactly everything you want carried out the way you want it immediately upon that life event. Okay? TODs also have a number of disadvantages. Okay? Like a POD designation, a TOD designation will also control the distribution of the account or asset, even if your will or trust includes a contrary instruction. Okay? TOD designations are also available on a limited number of assets. Okay? So, unfortunately, estate planning is complicated. It's very complex. My point in making this video, don't, like what just happened to me with this potential person I was helping. We sat down together. We went through 2 hours of information. I've coached her. I've helped her through it. And she took it to her daughter-in-law, and her daughter-in-law is like, all you need to do is get a TOD. Okay? Well, that's one of the many things that are needed, and the problem in this country is people don't know it. Okay? And the reason people don't know it is you're not, let's say you go and do a TOD, a POD only. You're not going to know the problems that arose or came up, the unintended consequences, as we call it, because you're either going to be incapacitated or you're going to be dead. Just be realistic about this stuff. Don't think, oh my gosh, I don't want to pay for anything to be set up. You've worked, think of it this way, you've paid for insurance, homeowners insurance, car insurance. You've paid all these insurances your whole life. Thousands, a huge part of your income. And every day that you pay it, you hope and pray you never have to use it. Where when you get involved with somebody like me that specializes in this, anywhere from $2,500 to $3,200, depending on how many assets you have, you get a full professional written plan, not documents. You get guided and you put a plan together. We help you do that. That eliminates any unintended costs. Now, I'm not on here to sell you. I'm on here to share this information with you so you can make an educated decision. I will guarantee you, you're not going to find information that I share. It's so hard to find. There's some people out there that do it, but not like me, not as passionate, not as honest. I'm not here to sell. I'm here to teach you this stuff and create awareness for you to learn it. Your job to learn it, okay? So anyhow, if you want this full document and have this in your hand, I'd be happy to get it to you. Just contact me. My email is estateplanningwi@gmail.com, and my website is estateplanswi.com. You can get in contact with me through there, or give me a call at 262-573-6138. God bless, and I hope you take the information to heart and use it wisely.